Welcome. Now, my guest still with us this hour, criminal defense attorney Joseph Tully, and joining us now, former senior homicide prosecutor Bernarda Villalona. Bernarda, let me start with you. In a case like this, when you have a relative who says, I'm just not surprised because look at these pictures of what she's been through before, allegedly at the hands of this defendant, and then you have a defendant who says, oh, self-defense, and then gets on the stand and says, no, it wasn't self-defense, it was an accident, I didn't do it. What are your thoughts?
It's heartbreaking when you hear about domestic violence victims that ultimately end up dying, because that's your worst fear as a prosecutor and also as a family member of that domestic violence victim, because you know it's just a matter of time before that happens. But what's even more insulting is sitting at the trial and watching that the man who took the life away from your loved one, and here, Mr. Chad Absher, you shot the woman in the head and shot her sister in the head, and now you want to say that what? It wasn't you? That actually it was the sister who killed her own sister? I'm completely appalled by his testimony. I'm upset by his testimony, and I share in the anger of the prosecutor when she delivered that closing argument. But I think it was a complete game changer when he took the stand and changed the entire theory that it wasn't self-defense, but more of that the sister was the one who killed her own sister, and that the gun went off and ended up shooting her in the head as well.
And then he finished it off with, and by the way, having an affair with Lisa, the sister. That was also part of his testimony. Joseph, let's talk about one of the things that Chanley Painter had as breaking news, and that is the possession of firearm by a convicted felon charge. 3 charges facing this defendant. And we learned right as Chanley joined us, it was going on inside of the courtroom a few minutes ago, that he has now pled to that charge, 3-year sentence, possession of firearm by a convicted felon. Tell us, from your perspective, is this surprising to you? Does this happen? Give us a little legal analysis about that.
Sure, it happens, but what's surprising is the timing of it. So imagine if he had pled at the beginning of the trial or before trial to that count. And then, he testified. The defense attorney could have argued to the jury, ladies and gentlemen, he pled guilty to what he possession of the weapon, and that which he wasn't guilty of, we went to trial on. The fact that they're pleading guilty to it at this stage after closing argument really doesn't do much for the defense.
All right, Bernarda, I have to ask you this, and do you think that one of the reasons the plea is being entered right now is because the state's apprehensive about what kind of verdicts might come back?
Well, it's not really a plea. He's pleading to the actual charge. He's not getting a discount by actually pleading. So it's his prerogative to actually if he wants to plead or not. In terms of the prosecutor, they're not offering him a deal. He's pleading to the judge, to the actual charge, without a promise of a certain sentence.
All right, you're both going to stay with us. Thank you for joining us today. Coming up next, the Verdict Watch continues in the controlling boyfriend murder trial. Look at your screen, 44 minutes, almost 45 minutes is how long the jury's been deliberating in this case. We will be looking back at some of the defendant's testimony from today. Stay here, Court TV, your front row seat to justice.